On the show, Leaving Jamala. It's good to have you.
Good afternoon.
So, there's this growing concern about increase in rents, right? And the question is, in Nigel, we can search and see a to speed.
I went through several of the provisions that regulate the relationship between I've not. The relationship between landlord and tenant is contractual in nature between the landlord and the tenant. And once both the terms have been considered by parties to be mutual and consent is given, consideration is made, that relationship is established. And so where the tenant is not comfortable, where the rate is not convenient for him, what do you do in a circumstance where you are going to sign a contract and the terms are not good enough, not protecting your interests? What do? You walk away.
Okay, so now where we find ourselves currently is a situation where the tenant will receive, as you can say, by XYZ. Because you know what some of these landlords do when they know that you would not pay the increase, they decide to give you an eviction.
Yes, okay. Which in the circumstances we have moved from tenancy agreement to a lease agreement. Now, once that is done, ordinarily the lease agreement should contain clauses as to whether or not the landlord has a right to increase upon the expiration of the term that you've entered.
Oh, interesting.
Yes. The contract, that agreement you enter between the landlord and the tenant is the document that binds the both of you, aside the laws that regulate removal, recovery of premises. No, so that agreement is basically the document that governs the two contracting parties. And so where there is, as to the position of that, the period within which the landlord can increase rent, at what percentage of the rent that the landlord can increase, when there's a lacuna, remember, the landlord will use the market force.
Interesting.
Yes, to regulate his bargain.
So you're saying, because if you're watching on Facebook, you can see me smiling, right? What you're saying is that a lot of the tenancy agreements are faulty. I mean, it doesn't capture some of the necessities.
Yes, I will not even hesitate to answer you. Most of Nigerians, most of us here in Nigeria, for the fear of engaging the services of a professional, in the circumstance, a lawyer, they look for anything they call a paper agreement. And so business centers, unfortunately, business centers, a lawyer will prepare a document somewhere in a business center, unknown to that lawyer that the business operator has saved the document. And so the next person comes, he reproduces that same document without knowing the necessary modifications. Agreements are written on understanding of parties. This is what I will be able to do, and this is what, there is a duty on the part of the landlord, there is a duty on the part of the tenant. There is an obligation on the part of the landlord. There is also an obligation on the part of the tenant. So where there is a duty, there is a corresponding obligation. So when you are not aware of all these things, and for the fact that we do not want to spend much, then we find ourselves, even in land documentations, some people will spend millions of naira. By the professional rules, a lawyer is expected to collect 10% of whatever that you have you are paying as a consideration for that purchase. But because you see someone buying a property of 15 million naira, is looking for a lawyer that will write it for 10,000, looking for someone that will write it for 20,000. And when none is available, they go to the nearest business center. I beg you, get a sample of so and so, and they reproduce. Now, when the trouble comes, a lawyer goes through it, finds the lacuna in it, and make very good use of it. So I really do not want to blame the government. I'll blame, sometimes it's ignorance, sometimes it's willful ignorance, and sometimes it's born out of our own greed.
Okay, so now let's come to another very interesting part. Agents.
Yes.
Because they also play a major role in increasing tenancy rates and all of that. Because you've just said, by right, both parties, the landlord and the tenant, should sit down, have an agreement in the company of their lawyers, right? But now we have agents usually playing the middleman role. What does the law say about agents?
Now, the relationship between an agent and the contractor in this circumstance is regulated by the provisions of the agency laws and agency acts.
Okay.
Now, because we are not aware, I'm also told that agents are beginning to collect 15% of the agency fee for whatever, and they also impose it on the landlord to collect some number of years. By doing so, their agency fee will increase. Mm-hmm. Now, the Agency Act talks about 5% for each of the parties.
Sorry, assuming 5% for who? For one agent, and 5% for who?
For the parties, each of the parties. Assuming party A is to dispose of a property, party B has indicated interest, C is the agent.
Okay.
Now, once we have agreed on the consideration and the title for that property is properly demised to party B, it behooves on party B to pay 5% of that consideration sum to party C, and party A also part with 5% to party C. So the total sum party C is getting is 10%, but not from one party alone.
But what we have, it's usually the tenant, who likely is party B, paying party C, the agent, the
by
10%.
The agency law is wrong. It's very wrong. But we find ourselves most times, it is the tenant who initiates or contracts the agents. Please, I'm looking for so and so. Then in some cases, it is the landlord who will say, please, if you see someone that desires this kind of apartment, I have one, I have two. Now, when the agent goes out and gets one, the relationship is now between the A and B. So from whichever angle you look at, the agent is the middleman between the two contracting parties. And therefore, the two contracting parties owe the agents the percentage required by law.
But what we have in reality is the tenant trying to reach a negotiation or agreement with, the agent. You meet an agent and say, but at 10% be my price. So. And then, the tenant is the one paying for it. And sometimes you even give them mobilization fees. That also allowed by the Agency Act.
It is not allowed. It is completely out of the law.
So what do I do? What do I do if I like a property and the agent is insisting that I have to pay the agency fee, 10% of it? What do I do? Or now 15%?
You test the law. The problem we find ourselves is that these houses are not there. And so agents then too were not aware of the provisions of this law. So the agents now make use of our ignorance and exploit us. But two, if we have these houses available, the fear of accessing or having an accommodation wouldn't be there. What stops you from, at the close of work in the evening, you move around to a particular place? But if you are not an agent and you are informed about the locations of this, of the availability of the nature of property you are looking for, you can walk from now till next year. You will not see an apartment colored.
And that's
that is where the agents.
Growing up, we used to see house to let. It used to be, but these days it looks like all of those things are now left for the agents. You must find an agent to be able to trace vacant houses in Port Harcourt, most especially.
Because we are of the lower class, there are property managers. Now, if I have the necessary resources to look for a particular apartment, I can contact any of these property managers to say, do you have this nature of building or property I'm looking for?
All right, we'll come back to you. Let's go for a quick commercial. When we come back from the break, we'll talk some more. About 31 minutes gone into the hour of 5, and we're still having conversations. Knowledge, they say, is power. And I've been enlightened just having few minutes conversation with Living Jamala, who's in the studio, is a lawyer here in River State. And I understand that according to the agency law, I'm not supposed to pay more than 5% to an agent. And of course, the other 5% should be given by the landlord to the agent. But agents now are here. I mean, 15% of the rent, they collect that. And I've also been told that when formulating an agreement before moving in, that I'm supposed to talk about exit as well. Exit should be in the contract. How am I going to leave? If I'm going to stay, should that be, XYZ amount in terms of increase in rent? Unlike what we see where the landlord will tell you, for your one bedroom, you used to pay 500,000, but now it is, okay, I'm not going to say it for those who have not increased their rents so that they would not know what the new price is. But Living Jamala, thank you very much for being a part of the show. It's good.
Thank you, Kalada.
Okay, so before the break, I think I was asking the question, about how, if it's possible to bypass agents, and you talked about property managers, but even those property managers, they're acting like agents. Would they not want to put the financial burden on the tenants who are looking for accommodations?
Property managers are also regulated by law.
Okay.
And where the need for agency fee arises, they are also fully aware that the percentage that the agent is expected to collect is that said 5%. And
From the tenant.
I've not seen where maybe there are a few who will also play on the intelligence of the tenants, but I've not seen where they somehow abuse that knowledge. I've not, to my limited knowledge.
Okay, so what's the deal like?
Paying you 100 years of rent. It is not within the right of the landlord. Paying you 100 years of rent. It is not within the right of the landlord to go and lock the gate of the tenant. Go and disconnect electricity. Disconnect water. The roof, landlord will also go to the extent of de-roofing, removing the doors to make the environment unconducive for the tenant, so the tenant can live on his own volition. That the law is against of it. There's a procedure. Now, there are types of rent. We have the weekly rent, we have the monthly rent.
All in the law?
Yes.
Okay.
We have the weekly rent, 7 days, the monthly, the quarterly, the half-yearly, and the yearly rent. Now, where you have reduced your tenancy into assuming it is 1 year rent, the law expects that if you intend to evict the tenant, you give that tenant 6 months notice to quit. Now, this is where the mistake or the misunderstanding starts. The tenant for up to 9 months, maybe so in a year's rent, to look for alternative. Now, where the landlord fails to do so, the court having somehow departed from those statutory serve owners' intention to recover
property.
This course were sought from again more pass through that procedure.
Okay. If a rent and the sewage is filled up, or something, the pumping machine, right, is bad, who's supposed to fix it?
You see, that is what I said. All those tenancy agreements provides for all these things
in the law.
Yes, there's what we call wear and tear, where there are some certain minor remedial works you may need to effect. If you like you talk about the sewage, who used it?
Me.
Yes. So who do you expect to evacuate? Now, if you are the sole person living there, is a responsibility to do so. But in understanding of that agreement, most times the burden is shared between the landlord and the tenant.
So that means we're back to the agreement
We're going
itself.
back to the agreement. That agreement is a document that binds the relationship between the landlord and the tenant.
Do you think the River State government can do something to ensure that these agreements go through the right procedures?
The River State tenancy law is there.
Okay.
That most of all these things are provided for the rights of the landlord, the rights of the tenants, procedure for eviction. Those things are there. But are the parties willing to subject themselves through that process?
All right. Now, let's come to WhatsApp, where this one says, please let's not disturb ourselves much in this issue. Many actions Nigerians take in their everyday life are usually done under duress and lack of options, with no superior effective regulation from legal authorities to provide alternatives when they want to insist on doing the right things. There is enough houses for those in need of it, so the man that has any available room makes his rules, and if you can't abide by his terms, you leave. It is an open air market. Everyone is fending for himself. But I'm going to take one or two calls before, because I do have a commercial break in about 5-6 minutes. So I'm going to take a call, 002-017-923-003. Someone is asking, please, drinking money landlords collect, is it right?
They are not provided for the law, please. These are some what I call it,
traditional
imported traditions into tenancy relationship. They are never provided for in the law.
So if I say I would, because I've had the situation where the landlord said he wasn't going to give the house because of drinking money.
If you had a choice to look for another apartment, would you succumb to?
But if I've already done the agreement, I can sue him for disturbance.
Once you have paid your rent and you've signed the tenancy, what is not provided for in that agreement is outside the contract agreement.
What about a situation where in a compound, they have one meter of some sorts? Who pays for the electricity? Or if the building in itself has got accumulated
yes.
debts that they are owing,
yes.
Who pays for those?
Now, it is a responsibility of the tenant to pay the utility bills that he has so far used.
Okay.
Not arrears of utility bills. So, therefore, it is the responsibility of the landlord
to ensure
that upon entering the new tenant entering, there is nothing arrears hanging on his neck.
My goodness. Let's listen to Braid from Old GRA. Braid, your thoughts quickly, please.
Good evening.
Yeah, greetings.
Barrister, good evening.
Good evening, sir.
Yes, the question I want to ask, if a tenant is being given an apartment and he stays for a period of time and he wants to back, and the landlord go in and inspect the property, and some of the properties, let me say like the toilet system is being vandalized, if the landlord have any right to tell him to replace those properties that have been destroyed before leaving, and if he refuses, what should be the actions of the landlord?
All right, you answer that, clearly. Promise I was going to get votes, but let's have the answer.
Now, in circumstances where the land damages some of the properties, it is the responsibility of the tenants to replace those things. Yeah. And where the tenant refuses, it is a right of the landlord to sue for damages.
But that's why we have caution fees, I guess.
Most times, those caution fees even enough to offset the damages by the tenants.
Oh, I see.
So, it's a precautionary measure for landlord to somehow
tenancy boils down to the agreement.
It's just that the answer that our friend Bray has asked.
So that means going for people. Be renegotiated. I give 3 months in there. I can go to landlord and say, "Hey, let's renegotiate it."
See, Calada, agreements is payment. Now you enter the contract, maybe not fully aware of the terms therein, and you find some clauses later on that somehow are inimical to your own interest. What do? You renegotiate.
What if the landlord refuses?
Then you are bounded by that until the expiration of that term. So long as you have signed and you have not shown any signs that you signed under duress, those mitigating factors
you should do, and the basics of it is you should be very, very conscious during the agreement period, when you're signing all of the agreements. But time would not let us go any further. Living Jamala, thank you very much for being a part of the show.
Thank you very much, Calada, and thank you, Rivers people.
It's been a wonderful conversation. You could see me smiling, and I've learned a lot on the show.
At least you are so away from politics, so that I've not been caused by